5, 4, 3, 2, 1, start. From the aforesaid provision, it is evident that a counterclaim can be filed against the claim of the plaintiff, and it can be filed regarding a cause of action accruing to defendant against the plaintiff full stop. However, in the light of the aforesaid provision, there is no question of a counterclaim being permissible against a co-defendant by a defendant in the suit full stop. Still, further perusal of the provision contained in Rule 6A states that in case the counterclaim is filed by the defendant, then the plaintiff shall be at liberty to file written statement in answer to the counterclaim full stop. Further, Rule 6C gives entitlement to the plaintiff to raise an objection to the counterclaim filed by the defendant before the issues are framed in relation to the counterclaim, and the plaintiff can make a claim that counterclaim of defendant be excluded from his suit, and the defendant filing the counterclaim may file a separate suit if he so desires. Full stop stanza. Likewise, Rule 6E provides that if the plaintiff defaults in filing reply to the counterclaim, the court may pronounce the judgment against the plaintiff in relation to the counterclaim made against him full stop. Even Rule 6F provides that the relief to be granted in the counterclaim is against the plaintiff full stop. This relates to express provision vis-a-vis counterclaim filed against the plaintiff full stop. In the entire provision, now where a co-defendant is contemplated as a person required to suffer a counterclaim against him by another co-defendant full stop. In the eventuality the defendant files a counterclaim against a co-defendant, the co-defendant has not been given any right to file written statement to the counterclaim under Order 8, Rule 6A, nor has a defendant been given any entitlement to make an application for exclusion of a counterclaim filed by co-defendant against him full stop stanza. Furthermore, it also not provides for pronouncement of a judgment against a co-defendant in the eventuality of default of co-defendant to file a written statement to the counterclaim by the co-defendant full stop. Thus, absolutely there is no provision made for permitting a counterclaim by defendant against his co-defendant full stop. In this regard, suffice to make beneficial reference to the observations by this court which dealt in detail with the provisions aforesaid and the implications of the counterclaim filed by the defendant against the co-defendant and the prejudice of the rights of the co-defendant against whom the counterclaim has been filed full stop. It is apt to reproduce the observations made by this court full stop. Hence, a bare perusal of the claim of Order 8, Rule 6A to 6D shows that it is only the plaintiff against whom a counterclaim is permissible full stop. It is only the plaintiff who has been given a right to file reply to the counterclaim full stop. It is only the plaintiff who can make an application for rejection of the counterclaim on the ground that the defendant may file a separate suit, and it is only the plaintiff on whose default to file the written statement the court can pass a judgment against the plaintiff, and it is only the plaintiff against whom any balance which is found due after adjusting the counterclaim can be granted to the person who is filing the counterclaim full stop stanza. In this entire scheme, now here a co-defendant is contemplated as a person required to suffer a counterclaim against him by another co-defendant full stop. In case defendant, then co-defendant has not been given any right to file written statement to the counterclaim under Order 7 Rule 6A full stop, nor has a defendant been given any entitlement to make an application for exclusion of a counterclaim filed by co-defendant against him full stop, nor the default of a defendant to file written statement in counterclaim by a co-defendant is prescribed as a ground for pronouncing a judgment against such a co-defendant full stop. Even the balance of their life after adjustment of counterclaim is not contemplated to be granted against a co-defendant by the CPC full stop. Therefore, expressly no provision is made for permitting counterclaim against co-defendant cannot be read into the statute book for the simple reason that such an implied presumption would go totally in contravention with the other provisions of the Order 8 Rule 6A to 6D full stop stanza. If any counterclaim by the defendant against his co-defendant is entertained by the court, then the court would be finding itself in a absurd situation where the court would not be authorized to permit filing written statement against the counterclaim by the co-defendant. The court would not be authorized to permit a defendant to move an application for exclusion of the counterclaim by the co-defendant, and the court would not be authorized to grant relief against co-defendant full stop. For assuming all the powers with court, again an implied presumption will have to be made that court has all these powers because it has permitted the counterclaim to be filed against a co-defendant full stop. This much of interpolation and reading into the statute, which is neither required nor is necessary and rather is prohibited by the law of interpretation full stop. Any omission to legislation, a point has to be presumed to be intentional on the part of the legislature or the rules framing authority full stop stanza. Any defendant has otherwise full right to file a separate suit against a co-defendant for any cause of action full stop. Therefore, no such interpolation of words and phrases in Order 8 Rule 6A to 6D is called for or permissible full stop. Hence, it is held that a defendant cannot file a counterclaim against a co-defendant under any circumstances full stop. Order 8 Rule 6A to 6D provide for and conceive of only a counterclaim to be filed by the defendant against the claim of the plaintiff full stop. Hence, the counterclaim against the co-defendant in the present case was not maintainable full stop. Learned Counsel for Respondents number 5 to 7 has relied upon the Bihar High Court judgment to emphasize that the counterclaim against the co-defendant is maintainable full stop. However, it is pertinent to mention that Honorable Supreme Court in the subject case had held that it appeared to them that the counterclaim has necessarily to be directed against the plaintiff in the suit, though incidentally or along with it may also claim relief against co-defendants in the suit full stop stanza. However, perusal of the dictum of the Honorable Supreme Court reveals that the question is as to whether the defendant can file counterclaim against co-defendant was never as such considered in that case, as the moot question before it was with regard to counterclaim having not been properly filed in that case full stop. It was the stage at which counterclaim can be filed which was in dispute full stop. Looking at this case within bracket supra, it has been observed that this judgment is not the precedent on the point that the defendant as a matter of right can file counterclaim against co-defendant as an independent remedy, and it was also observed about the Honorable Supreme Court having held that the counterclaim as necessarily to be directed against the plaintiff in the suit, full stop.